The Raising the Bar podcast, brought to you by the Association of Gray's Inn Students.
Hello and welcome to the Raising the Bar podcast with me, Alana Hughes. This is the Meet the Barrister series, in which I speak to a different guest barrister on each episode. The aim of the Meet the Barrister series is to demonstrate that the bar is not a one-size-fits-all sort of profession as it is sometimes wrongly assumed to be. Barristers come from a wide variety of backgrounds and specialise in many different areas of law. There is something for everyone. Tonight's episode is a very special one in that this is the first Meet the Judge episode as part of the Meet the Barrister series. His Honour Judge Aubrey QC was called to the bar in 1974 and practised for over 30 years in Liverpool, specialising in crime. His Honour Judge was appointed a recorder in 1995 and then took silk in 98. He was then appointed as a circuit judge on the Northern Circuit in 2005. His Honour Judge is a bencher at Gray's Inn and has very kindly joined me this evening to give an insight into life as a busy Crown Court judge. Hello, Judge, and welcome to the podcast.
Hello.
I just want to start our discussion tonight with some information about your background and where it was that your interest in law came from.
Well, I came from a very ordinary family. I had no legal background in terms of relatives or friends in the law. In fact, I initially wanted to be a social worker, but my father didn't think too much of that, and he suggested the law, and so it was, albeit reluctantly, that my career path began. I was the first in my extended family to go to university, although that was in doubt as my A-level grades were in truth very modest, and I'd already applied to a number of polytechnics as they were then. Liverpool, to my surprise, accepted me. My father died in my first year at university, and that was a challenge in itself. And so my interest in the law began from university days. Looking back, perhaps I could say this: I had two clear advantages. I went to a good state grammar school, which instilled a strong work ethic, and I was fortunate in that I had a supportive family, not in the financial sense, but in so many other ways. Money was tight. My father was deceased. My mother did not work, although I was fortunate. I obtained a local authority grant and I was awarded 2 exhibitions from the inn. I also worked on building sites and with a dust cart to supplement my income, which enabled me to complete a 6-month pupillage in London before I commenced a tenancy in Liverpool.
And in terms of the early days of your practice, were you keen to specialise in crime for the very beginning, or how did that trajectory come about in terms of the development of your practice?
It was always my intention to practice in crime. I'd gained that pupillage in London through the inn. I cannot say that the process was as competitive and as formal as it is now, but perseverance and good luck won the day. But there were many pupils in chambers. I was not able to obtain a tenancy in London. Can I say we were in the 70s, and the last 2 tenants taken on, their fathers happened to be judges at the Bailey. But we have progressed. So it was, I moved on back to Liverpool to a bedsit and a second 6 months pupillage, and thereafter a tenancy in Liverpool. Always my intention to practice in crime, but I had obtained that pupillage purely by chance, being at the right place at the right time. I'd not been subjected to the strains and stresses of those applying for pupillage now, but that is not to say I've not had setbacks and rejections along the way. However, my life in the law, the criminal law, was now just beginning in 1975.
And so you spent 20 years at the junior bar before you decided to take silk. What factors were in play in your decision to take silk?
Well, taking silk, that was a big step. Again, it was something I believe I grew into. Why did I take silk? As a junior at the criminal bar, I felt I could do that, and sometimes even felt I could do that better. I hope that doesn't sound arrogant. It wasn't intended to be so. And then I made an application for silk. I didn't get it the first time round. In actual fact, another David Aubrey, Queen's Counsel, took silk that year, but I received so many letters of congratulations, I thought I ought to put my hat in the ring for a second time, and on that occasion I did succeed.
And in terms of the very sort of general and broad changes that taking silk brings about for your practice, can you reflect on those and sort of provide a bit of an insight to listeners into how your practice might change broadly when you take silk?
Well, as far as I was concerned, whilst I did practice in Liverpool, I was instructed elsewhere around the country, and it involved a lot of travelling. So I was away from home a considerable amount of time. I remember there was a solicitor who probably should have been sectioned, but sent me a lot of interesting, rewarding and challenging work. But it meant, as I say, that I was away from home and my son was young. So I started to think for how long I would be in silk for.
You are the first judge to join me on the podcast, and I think that a lot of people would be very interested to hear from a judge's perspective about the process and procedure of that career change, essentially, from a barrister to a judge. At what point generally do barristers in their career begin to think about becoming a judge, and then more specifically, at what point did that become a career plan for yourself?
Well, let me start, if I may, with the appointment process. The appointment process to the judiciary is now very different. When I was appointed a circuit judge, it was the year before the Judicial Appointments Commission came into being. The process now involves exams, interviews, competence tests, role play, and the like. It is rightly far more transparent that it was when I was appointed. But I firmly believe there are some who somehow are born to be judges. Others simply grow to become judges. But there is no doubt that the touchstone is most definitely possessing the necessary competencies and not any other factor. When I decided to apply to become a judge, I had considered that I may now possess the necessary competencies. But that is when one might start thinking about being a judge.
And what, if I may, would you consider those key competences to be?
Well, the skills required there are many. It's a long list of independence, impartiality, integrity, confidence, a calm authority, humility, propriety, a thorough knowledge of the law. But it's even more than that, in my view. It's about listening. It's about being patient. It's about being fair, understanding people's weaknesses, self-awareness, acknowledging one's own bias and prejudices, recognizing unconscious bias and much more.
Just going back to the process of a move to the judiciary and an appointment to the judiciary, some research that I tried to do online about how barristers take that leap showed up that traditionally becoming a recorder was the first step on the judicial ladder for barristers, while solicitors tended to become district judges. I don't know if that was your experience or if you think that that tradition remains alive now.
Well, I have no doubt whatsoever that solicitors make extremely good judges, and now they have the opportunity so to do. As I said earlier, the focus is on the necessary competencies, and it's illustrated now by a much wider eligibility. Age, young age, is another factor. Judges now are appointed, some of them at an extremely young age. Why is that? Because they have been through the process, and the Commission has determined that they do possess the necessary competencies irrespective of age. I just make a brief reference to diversity. I believe the judiciary is becoming more diverse. That does not mean that we do not have a long way to go, and to ensure that we are truly representative of the society that we serve. But it does take time. Being a recorder does allow one the opportunity to ascertain whether the judiciary is for them. And it is a very different skill, if I may use this expression, acting as a referee as opposed to being a striker. I have certainly been aware of some recorders who have discovered while sitting that in truth it is not for them. But there is no doubt that it is the first step on the judicial ladder.
How difficult do you think it is to exercise that juggling of wearing the advocate's hat one week and the judicial hat the next week, which is, of course, what recorders have to do while they are part-time sitting?
I think that can be very, very difficult. From my own experience, when I sat as a recorder, perhaps for a week or two, I felt that I was just learning to possess the competencies, the skills, acting as a referee or umpire, making sure that I was not entering the arena. And then my time sitting as a recorder for a week or two had come to an end. And then I would wait before I was sitting again, and then the whole process would recommence.
You've spoken about the judicial competences that are required of a judge. And just for the benefit of our listeners, I want to read out the promise that is contained within the judicial oath, which is that you will do right to all manner of people without fear or favour, affection or ill will. And you have mentioned impartiality as a competence that is required of a judge. I wanted to ask, how difficult is it, especially in the world that we live in today with mass media at our fingertips instantaneously? How difficult is it to remain impartial, particularly on the sorts of cases that are making the headlines and hitting the newsstands before they have got to your bench?
Well, the first thing I would like to say as far as the oath is concerned, I try and look at myself in the proverbial mirror every single day and remind myself of that solemn oath that I took to do right to all manner of people without fear or favour, affection or ill will. I also remind myself that for all those in front of me, it is one of the most important days in their lives. I would like to think that that not only keeps me grounded, but also reminds myself of the oath that I took, and also that external factors that you have just mentioned, in truth, do not pass through my mind.
On the one hand, two questions. What do you enjoy most about being a judge? And then on the other hand, what is the most challenging aspect of your judicial role?
Firstly, it's a huge privilege to see and hear about aspects of people's lives that most people do not. That is a privilege and a pleasure. You do have enormous power. You must use it wisely in accordance with the law. But the enjoyment that I have is that every single day is different. Every single day you will meet the mad, the bad, and the sad. Regrettably, almost every single day you may have to sentence the mad, the bad, and the sad. But it is the vast array of cases that may come before me, whether they be class 1 cases of murder, or alternatively those offences at the lower end of the criminal spectrum. But I remind myself that it's a huge privilege to see and hear about aspects of people's lives. It is one of the most important days in their respective lives. And that is why I still, if I may use the expression, enjoy my work, albeit that I may well be coming or entering the autumn of my judicial career. You mentioned challenges. There are many, but what do I find the most challenging? I would say trials involving young defendants, and if convicted, sentencing them. You have that young person's whole future in your hands.
Just following on from that then, and I suppose reflecting on your career at the bar before you became a judge, is there anything in particular that you particularly miss about private practice? And I wonder if it might be that in private practice you had the opportunity to defend those young defendants as opposed to having to be in the position where you're making a huge decision that will affect them for the rest of their lives.
Yes, if I may, just before, and I've been reflecting on that last question as far as challenges are concerned, let me also say this. Every day, a judge is dealing with the trials and tribulations of a fellow human being. You have to remain objective, dispassionate, and focused. But there are always bound to be challenges, for example, sentencing and causing death by dangerous cases. They provide their own challenges. There simply are no winners in such cases. The death of a young child or sentencing a single parent to custody are yet further examples. But you asked me what I miss now that I am on the bench. Well, when I first went on the bench, I missed much. I missed the camaraderie of the bar. I missed socializing. I missed my friends from chambers. But I've been fortunate that whilst I missed such people, friends, colleagues from chambers, In times, I have found many friends amongst the judiciary, but I'm glad to say that lawyers are not my only friends.
Do you miss the advocacy?
I did initially. As I say, it's a very different world being a referee or an umpire to being a striker, to being the leader of a team, directing your team, involved in advocacy and the adrenaline of all that entailed. But in time, you learn, you must step back, be objective, be dispassionate, and perform a very different role.
And in terms of advocacy, I'm a second six pupil very recently on my feet, and although I don't specialise in criminal law, I would be very keen to know, as I'm sure many listeners of this podcast would, about the tips for advocacy from the judge's perspective. What is it that barristers can do in terms of their advocacy to be most helpful to a judge?
Well, the first thing is I'm glad to hear that you are in your second 6 months pupillage, and I wish you all the best and good luck for the future. It is a great life being at the bar. But if I were to give 3 advocacy tips, it's preparation, preparation, preparation. If you are prepared, you are confident, and with confidence, but not overconfidence, should come clarity, calmness, and order.
And in today's world, where especially I think as a pupil or a junior, we are confronted with very last minute briefs. We are chasing very last minute papers, and the element of preparation is something that we would love to have, but it's just not possible in the time afforded to us. How do you think we might best present our case in front of a judge without having had the opportunity to prepare as much as we would like?
Well, spontaneity can sometimes be an art of advocacy. But I would like to, if I may, turn that question on its head for a moment. Because if a judge perceives that an advocate is ill prepared for a case, there may be many reasons for that ill preparation, such as the one that you have just made reference to. It is a late return. You have only just received the papers. And I have seen, regrettably, judges becoming annoyed with ill preparation. And one of the qualities of a judge is not to become annoyed. And it's a very fine line between annoyance and bullying, or the perception of bullying. And there may be many good reasons why an advocate is ill prepared. It may be late instructions. There may be issues as far as that advocate is concerned. If it is laziness, then there is, in truth, no excuse for it. But for a judge, and in part I'm revisiting one of the questions you asked me earlier, it's then how you manage those issues that is all important. It's absolutely essential for a judge to respect all in front of you, exercising a calm authority in a controlled manner. I ensure that I never, if I may use the expression, tell advocates off, and always seek to deal with such issues in a constructive way. So as far as the advocate is concerned, who may be ill prepared, if necessary, ask for a short while so that one can seek to prepare oneself more. If they're late instructions, it may well be that one is ill-equipped at that time to represent one's client. As I said earlier, it's one of the most important days in their life, and one must do everything possible in those circumstances to ensure that the advocate is able and well equipped to ensure that his or her case is properly presented before that judge.
You mentioned that you don't tend to tell barristers off in your courtroom. Is that limited to the issue of not being prepared because of late instruction, or is that something that you would do generally? And I suppose I'm asking this question as part of a wider question, which is, are there certain things that a barrister might do which particularly annoy you as a judge, or certain things that barristers do generally which you're aware of are an annoyance for the judiciary?
Well, as far as quote unquote telling an advocate off, it may well be that an advocate does ask an inappropriate question, or alternatively is repetitive in the questions that the advocate is asking. But I am firmly of the view that it is possible for a judge to move the case on, to remind the advocate that in truth that was an improper question, but it's not so much perhaps what one says, it's how one says it. As far as any annoyance is concerned, I do get concerned if, for example, an advocate is late, if witnesses are kept waiting. Again, I seek to remind myself that there may be good reasons for standards not being adhered to, such as punctuality, and an advocate being late that one is not aware of. So I think it's important for a judge, if I may use the expression, to engage brain before necessarily either becoming concerned or annoyed about a particular issue.
The final topic that I hope to ask you some questions about this evening is that of well-being at the judiciary. Now, we know that well-being at the bar has become much more prominent a focus for barristers over the past few years, and something that is very much promoted by the Bar Council and BSB. But we do know that the courts are under enormous pressure, particularly in light of the pandemic over the past 12 months. And you've mentioned already this evening how precious indeed the court time is. I just wondered, in terms of the workload for judges and time management, is switching off for you very important? And to what extent do you have to personally deal with these pressures?
There is no doubt that a judge can be under enormous pressure. We're all human, and we do not lose our inner being when we walk into court and sit on the bench. But in order to perform our judicial duties, it's essential that we remain objective, dispassionate, and detached throughout. But that's not to say that I have not been affected, for example, by certain cases. And it's difficult sometimes not to feel emotion, but one must hide it. I've been moved by many a victim personal statement, and in one case moved by the raw grief of a mother and the deep remorse of the defendant. I do not intend to disclose the details out of respect to both, but that day will stay with me forever. So there can be much pressure, but there are a number of mechanisms to deal with that pressure. One must keep things in perspective, and talking to my wife would be and is my first port of call. Colleagues are also a tremendous sounding board. Other than that, it is important to switch off at times, taking holidays, having outside interests. And I also remind myself how fortunate and privileged I am to do that which I do.
Finally, I want to ask if there are any standout moments or notable highlights from your career that just shine like a spotlight as you reflect back on everything that you have done.
As far as standout moments are concerned, there are in truth so many, but my standout moment is always my last case, the last person who has been in front of me. But I am proud of certain things, and if I'm proud in truth of anything, it has to be always trying to do my best, trying to do right. But if I had to choose one thing, it is having been involved in the advancements we have made in the criminal justice system as to how we approach children giving evidence and the opportunity for them for their cross-examination to be pre-recorded prior to the date of trial. Another standout moment that I have, of which I am proud, and it's given me considerable satisfaction, is that I am with another judge in Liverpool in the process of setting up an internship, a competition by going into schools in disadvantaged areas and ultimately selecting a student for a year who would be able to come into court, observe the criminal justice system. A grant will be available to that intern. The pandemic has delayed its implementation, but I am excited by it in order to give disadvantaged students opportunities which they might not otherwise have had. And that also applies to those who've had the experience of the competition itself, albeit they are not selected each year. So those are my standout moments.
For anyone listening to the podcast this evening who is particularly interested and keen to hear more about the internship that you've just spoken of, are there any further details in terms of a name that they may be able to Google for the scheme, or how they might keep an eye out for when that scheme becomes released?
Well, we are doing it in actual fact in conjunction with Everton in the community. It is going to be Merseyside based, and we have already, or we did prior to the pandemic, select particular schools that we are actually going to go into, talk to these students, and then set a competition for them. But I'll gladly, in due course, supply the details if anybody would wish to know more.
And perhaps this sort of scheme, which is really very one of a kind and the first of its sort that I'm aware of anyhow, may become a flagship for similar schemes to crop up in other cities in the country.
Well, I'd like to think so. We can't claim that we are the first of its kind, because I believe that at the Old Bailey, a similar scheme is in being.
My very final question this evening, and I think on the basis of everything that you've shared with me tonight, I know the answer, but it's a question that I love to ask my guests because I think everyone's reasoning for their answer is very different, and it's always intriguing to know why it is that people get out of bed in the morning to do the job they do. And so my last question is, do you love your job? And if so, why?
I'm going to answer that question in 4 sentences, if I may. I do love my job because it has given me an opportunity to try to make things better, to try and do right, as I say. Isn't that what justice is all about? Giving those who have been wronged a sense of justice. I love my job because, as I said earlier, you do meet the bad, the mad, and the sad. I love my job because every day is different. And as I've already stated, for most who appear before me, it is one of the most important days in their lives. I also love my job because you are afforded the opportunity on occasions to give someone a second chance to straighten his or her life, opening someone's eyes to the harm they have caused in the hope that he, she, and others can be deterred from living a life that ultimately destroys not just them, but others too. Perhaps that's why all those years ago I was thinking about becoming a social worker, but life took a different course.
Judge, thank you very much for joining me this evening. It has been so insightful to hear the answers to your questions from the judicial perspective, and I think it's a very rare thing indeed. And I'm sure our listeners will be very grateful and intrigued with everything you've shared. So thank you very much.
Thank you very much indeed.
Thanks for listening to the Raising the Bar podcast. Please subscribe, rate and review. And for more information, check us out on Twitter at RaisingTheBarGI.